couple of other threats that I haven't mentioned that these a will or a revocable living trust can protect you and your beneficiaries from is the unintentional disinheritance and creditors. Both wills and both revocable living trusts have the ability to make sure that creditors of your beneficiaries cannot get more than what they're entitled to, or we can actually defeat creditors' claims if they don't follow the appropriate mechanism that the law sets up to collect. So we can avoid certain creditors and having to pay them. Unintentional disinheritance, what that is when somebody is, let's say it's a couple, and they've been married 50 years and they've got 2 kids and they both agree, of course, when we're both gone, we want our kids to get whatever, whatever's left. And then what happens is one dies, and then sometimes this happens at age 70 or 80, the person who's a surviving spouse remarries and they fall in love and they get in a new estate plan. And that new estate plan might be set up just like the couple's old estate plan was, which is everything goes to the surviving spouse. Well, if that's the situation, then the surviving spouse, let's say it's the person who's the new spouse, they're the survivor. What ends up happening is that the children from that first marriage, they end up getting nothing. That happens much more commonly with blended families. The way to avoid that is through setting up trusts for the surviving spouse so that they don't have the ability to redirect assets. That can be done through a will or through a revocable living trust. Again, as an estate planning lawyer, as elder law attorney, what we're thinking about are the what ifs. And so many times clients say, oh, I've never thought of that. Well, of course you haven't, and you shouldn't think about that. My job is to make sure I think about all these threats, all these things that might happen, so that your estate plan has all these protections in place so that you don't have to pay unnecessary estate taxes. We protect assets against long-term care costs. We make sure your beneficiaries get what you want them to get and not some new family. That we protect assets for your beneficiaries. Let's say one of your kids is on government benefits. We don't want to lose those. So we'll make sure their benefits go to an asset protection trust, just like the one that I described for the surviving spouse against long-term care costs. That kind of a trust is a discretionary trust. It's called a supplemental needs trust. What that means is that the government doesn't believe that those assets in there that are for the benefit of the person belong to the person, because they don't. And therefore, those assets don't interfere with government benefits. We can set up trusts for the beneficiaries to make sure that if there is a divorcing spouse of that beneficiary, they never get any of that money. It is protected against the divorcing spouse, against creditors, against any sort of threat that I can envision as an estate planning and elder law attorney. So there are very definite actions that can be taken to make sure that none of these possible threats will eat up your money, and either during your lifetime or once you are gone.